This guy already landed himself 6 months in jail just for yelling at the wrong judge. And today? He's back in court. Let's see what he's about to do this time. Hey guys, and welcome back to today's video. Today we are covering 2 court hearings, and one of them is an update to a recent court crash out. Let's start with the update, where we have a defendant who is charged with stealing something off of someone's porch. Now this guy is no stranger to us. The last time we saw him, he decided to yell and cuss at the wrong judge and walked himself straight into 6 months in jail. So the big question is, did this guy actually learn his lesson? Or are we about to see the same drama all over again? Let's head inside and find out.
State, would you please set a record for James Broadway?
Yes, Your Honor. Thank you. This is State of Indiana versus James Broadway. There are 2 cause numbers, 64D01-2602F61333 and 64D01-2602F61636. The defendant is present in court in person by video conferencing without counsel. State of Indiana by Gary Gurman.
Morning, Mr. Broadway. Can you hear me okay? So first, I'm required to advise you of your various rights in this matter. You have the right to hire an attorney to represent you. You have the right to have an attorney appointed to represent you if you cannot afford an attorney. You have the right to a public and speedy trial by jury. And you have the right against self-incrimination. That means you could not be forced to make any statement or testify against yourself at any hearing or trial held in this matter. You understand those rights as I've just gone through them?
Sure.
Okay, and you've been charged here in F61333 with 1 count. This cause states that on or about February 4th, 2026 in Porter County, you did knowingly or intentionally, it's actually on February 5th, 2026 in Porter County, that you did knowingly or intentionally exert unauthorized control over a Laura Geller Compact Foundation belonging to a Jennifer Badola by taking the package from her porch and with the intent to deprive her of any part of the property's value or use, and that upon a criminal records check, law enforcement determined that you have a prior unrelated conviction for theft or conversion from 2018 in Porter County. You understand that allegation?
Yes, I returned that package to.
Sir, do you understand what they allege you did?
Yes, and I returned it to the police officer, and he said he was not going to charge me with anything.
What's important for me to know is that you understand what they allege.
Yes.
Okay. And it's charged as a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison and up to a $10,000 fine. You understand that possible penalty?
Yes, I want to go pro se.
Okay, let me get into the next part first.
But I just
First, I'm going to enter a preliminary plea of not guilty for you on count 1. And then the state filed on February 25th a habitual offender enhancement. Have you received a copy of that?
I haven't received nothing. Can I say something?
Go ahead.
This case that you're talking about is a summons for March 20th. We're not even talking about why I'm here when I got transferred. That's what I don't understand. That's why I fired off at you.
Yeah, I understand, Mr. Broadway. Like I explained the first time we met, the summons went out, but because you were already in jail, they wanted to make things convenient. So they just wanted me to do the initial hearing while you were already in custody, which was fine with me. So the February, what was it, 20th or whatever date the summons date was, that was vacated. March 20th. So you don't have to be here on March 20th. That date was vacated.
That means your speedy trial is something that I'm still talking about why I'm here. From Speedway and the possession charge was Clymer transferred me to you for that charge. And none of that is being discussed right now. I have 3 different cases going on. I got a Toadies case with false informing, and we got pulled. We didn't even get pulled over. We ran out of gas. and they said they were going to help us. And then now I came here, got re-OR'd, I'm say. So I just want to go home, sir.
Well, surprise, surprise, that's absolutely not about to happen. This guy thinks he's just going to walk right out of that courtroom like nothing happened. But unfortunately for him, he still has his 6-month contempt of court sentence to finish serving first. You don't get to yell and disrespect a judge and then just skip out the door like everything is fine. Sit down, buddy. You're going nowhere.
And we can do
Understand,
this.
Mr. Broadway? You keep doing a couple things which you need to stop doing. One is that you keep talking about your defenses out loud in front of the prosecutor. You should not do that. You should only talk to about your defenses in front of your attorney. If you're going to represent yourself, you need to do that in some proceeding other than in front of me, because I don't need to hear any defenses until your cases go to trial. You talked about the pending case you have in front of Judge Tody. I'm aware of that. You've got the pending matter in front of Judge Tody. That's why when I'm done with the hearings that I have to complete with you today, I'm going to transfer your case to Judge Tody because he's got cases. Also, Judge Clymer transferred your case to me. I should never have had that case. It should have gone to Judge Tody because he's got the pending case, the first pending case. Okay.
I understand. Thank you.
You were in jail already on F61636, which was the case that came to me from Judge Clymer, right?
No, I was not.
You were. They arrested you. You were in jail.
Sir, I got a summons by the officer. He told me that he was not going to press charges against me if I returned said package. I did that.
Okay.
The next, hold up.
I'm talking about one case. You're talking about the other case. But in any event,
you're talking about the March 20th package. I'm in here for Speedway, taking food out of Speedway and having a box that was in my pocket that I found.
That may have been why you were arrested, Mr. Broadway, and I'm not going to disagree with you. That may have been why you were arrested on F61636. You were already in jail for that, and then they saw that you needed to have the initial in F6133, and to make matters easy, they brought you in front of me last Thursday so we could do the initial hearing on that.
But that's not stating why I'm here. This case, why I'm here, is not what you're talking about. But what I'm saying is the officer said he was not going to press charges if I gave him the said package. I gave it to him. The next day, and my door was even open, and it had a piece of plastic.
Broadway, I need to get through one more part, okay? You keep talking about your defenses. It does not help you.
I'm not. I just want to go home, sir. I keep getting set up to be here, and people get let out of here that has worse charges than me. And
Mr. Broadway, I need to go through the habitual enhancement notice with you as well. You have been filed. The state has filed a habitual offender enhancement notice on February 24th, 2026. I would like to go through it with you. It says that on or about October 7th, 2024, here in Porter County, you were convicted of a felony in 64D02 2406 F6 6181, maintaining a common nuisance, which occurred on June 5th, 2024, and that based on that conviction, you were sentenced on October 7th, 2024 to 360 days in the Porter County Jail, which was suspended. They also say that on June 25th, 2018, in Porter Superior Court 6, you were convicted of auto theft in 64D06 1801 F6 603, which was committed on January 18th, 2018, and then based upon the conviction, you were sentenced on June 25th, 2018 to 365 days in the Porter County Jail. They also say that on January the 6th, 2012, in Porter County, you were convicted of a felony in case 64D01 1108 FD 7679, intimidation, a Class D felony committed on August 12th, 2011, and that based upon that conviction, were sentenced on January the 6th, 2012 to time served in the Porter County Jail. They also say that on December the 1st, 2003, in Porter County, you were convicted of a felony in cause 64D010010DF 8173, possession of marijuana, a Class D felony, which occurred on 26th of September 2000, and that based on that conviction, you were sentenced on December 1st, 2003 to time served in the Porter County Jail. Do you understand what they allege are your prior convictions related to the habitual offender enhancement notice? Do you understand what they allege?
No, I don't. That's not my charges. That's not me. My name is Jamie Clifford Broadway. Not James Clifford Broadway. Jamie Clifford Broadway.
Oh wow. So this is the defense we're going with today? The classic "it wasn't me, it was my brother" move. How original. How creative. Except for one tiny little problem, we actually have you on video, with your own mouth, admitting that you are exactly who they say you are. You literally confessed. And now you're standing there trying to sell us this story? The audacity is truly breathtaking.
My name is Jamie Clifford Broadway. Get that right. My name was changed when we came back from the war.
30 days.
So let me get this straight. By your OWN admission, your name was James Broadway before you changed it to Jamie Broadway. Bro. That is literally the same name. You just swapped one version for another. That's not a new identity, that's not a fresh start, that is the same nonsense with a slightly different label slapped on it. Did you really think that was going to fool anybody?
Okay, sir.
Explain
That's what the state alleges for the habitual offender enhancement notice.
Do
You understand what they allege?
I understand that. I hear that, but
Okay.
I don't agree with it.
I understand, and nobody's gonna. In a few minutes, I'll enter a not guilty plea for you on it because you're innocent until proven guilty in this country. I need you to understand that the possible sentence related to the habitual offender enhancement is that you could have an extra 2 to 6 years if you're convicted of a level 6 felony, 2 to 6 years additional term, and it's a non-suspendable additional term. Okay? So if you're found to be a habitual offender, an additional fixed term between 2 to 6 years for level 6 felony can be imposed at the time of sentencing. Do you understand the possible penalty?
I do, and
Okay, that's all I need. And as required by statute, the court will enter a preliminary plea of not guilty for you on the habitual offender enhancement. Now, I'm transferring your case to DO6. Both of these cases get transferred to Judge Tody, and you have a hearing set with him on June the 15th at 8:30. So you'll be back in front of him on June the 15th at 8:30. And you should have copies of the order that I signed yesterday, or I'll sign today if I haven't signed it, that is the sentence for the contempt finding. I found you guilty of contempt last Friday, and I sentenced you to 6 months in the Porter County Jail. That's another reason why you'll be sitting in the Porter County Jail until the June 15th.
Well, then I can't go pro se like I got escorted out of your room because, I mean, I don't want to look like this in the courtroom. I want to presume, I got court.
You said you want to proceed
I
pro
got court
se.
clothes at home that I was ready for court.
You said you want to proceed pro se.
Like
You
this,
want to
I
proceed
don't
pro
understand
se.
why you can't OR me and I be in court with my suit or tie.
And he will have to conduct a Feretta hearing related to the pro se. But in the meantime, I believe I have a duty to make sure you have an attorney within 20 days of being arrested.
I don't want an attorney,
And
sir.
I'm going to appoint the Porter County Public Defender Service
I don't
for you.
want that. I'm my own attorney. You know that. So does Judge Tody.
I don't
It's
think
so
you can get
simple.
Feretta
It
hearing,
is so
sir.
simple. I'm not a flight risk. You all know where I live at. I'm sorry
you're
for
in jail
raising
now
my
because
voice,
I sent
but
you
I'm always put as a
6 months
different in this place.
for your contempt last Friday.
I
transferring the
don't
case.
call
We
that
have a
being
hearing on June the
You
15th.
said something about
Go to
chickens, sir.
Judge Cody.
That is
and
not
we'll adjourn.
professional. And
We're adjourned,
you
sir.
got that word me and nothing. I'm not.
And that is the end of that chapter. I love how the judge handled that one, cool, calm, and absolutely savage. Because honestly, this guy calling out anyone else on judicial professionalism is like a toddler giving driving lessons. You have absolutely zero credibility to be critiquing anybody in that courtroom. Enjoy your time in jail, my friend, you earned every single day of it. Now we move on to our next genius, and this one is a special kind of special. This guy is facing charges of assaulting store employees, and why? Because those employees had the absolute nerve to ask him to actually pay for the items he was trying to walk out with. The disrespect of it all.
Court will call People versus Ryan Wagster, 26 CR 323. Hello, sir. Are you Ryan Wagster?
Yes, sir, I am.
Did you understand your rights in the advisement?
Yes,
Have you ever been in the U.S. military?
no,
Charges are third degree. Actually, it looks like maybe the charges are still being decided. But allegations are third degree assault and attempted robbery. Do you understand the nature of the allegations?
yes,
I reviewed the affidavit. I found probable cause for the arrest. I will issue the protection order. This is a VRA matter. Do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. Vacate the home of the victim. Stay away from the home of the victim, but also stay away from any location that the victim might be found. No contact whatsoever, and do not directly or indirectly communicate with the victim. No contact whatsoever. Based on the fact that this occurred at her business, Ms. O'Hara, even if I did know the home address, I would not list it. Any quarrel with that?
No, Your Honor.
All right. Bond argument, Ms. O'Hara?
Your Honor, the defendant does have a very lengthy criminal history dating back into the 90s, and it does include felony attempted second-degree assault, attempted burglary, a menacing as a felony, a second-degree assault as a felony, along with other misdemeanors on his record, thefts, harassments, violation of protection orders, things of that nature. Obviously, the facts of this case are very concerning to the people based upon the fact that the victim in this matter, as well as Mr. Perez, were simply doing their job and working at the Family Dollar and were attempting to confront the defendant about the potential for a theft when the defendant punched the victim. So obviously that is very concerning and is an extremely aggravated case, I guess. It went from what could have been a simple theft to now something much more serious, and it could be something even more serious. I don't know the extent of the injuries to the victim, if there was anything more substantial. But based upon all of that, I am asking for a $25,000 cash or surety bond with pretrial.
Bond argument, Mr. Duran?
Thank you, Judge. What I can say, as the court's well aware, is that this case is alleged to have been from May of 2025, and there was, it appears, recent identification attempts based on the detectives from Greeley Police Department in the affidavit. What I can say is there hasn't been additional cases or law enforcement contact or anything at this time. As far as we know, Mr. Wagster was compliant with officers. I can say that most of what the district attorney noted in the argument were, from what I could see, misdemeanor, previous criminal history, unrelated previous criminal history to this type of charge, and as she noted, relatively old. I can also say that Mr. Wagster lives in a house here in Greeley that he owns. He's going through a lot with that home, though. Someone apparently tried to quitclaim the deed for the home illegally, and Greeley Police is investigating that on behalf of Mr. Wagster. He lives by himself. He has a dog that's currently staying in the home that's not cared for because he's not there. He's taking care of his neighbors, and he's working on getting approved as their permanent in-home caregiver. He does have transportation to be able to make it to and from his court dates. He is okay complying with pretrial services and GPS monitoring for the court. The parties can't see it. He had a case in Denver that was dismissed and sealed 2 weeks ago where he was compliant on pretrial services. And he's willing to do that again. Obviously, this came as a complete surprise to him, given the age of the case, and not knowing about the warrant. But he's willing to do everything he can to be successful on bond. We are asking the court to consider a personal recognizance bond. He has no issues with any protection orders the court may set here.
Yeah, that's going to be a big fat note from the judge. Here's what makes this even better. It has been months since this assault went down. Months. And this guy has known the entire time that these charges were out there waiting for him. He didn't just forget. He didn't just miss it. He made a conscious decision to avoid facing the music for as long as humanly possible. And now he wants to act surprised that the court isn't exactly in a generous mood.
Well, he may have thought that whatever the issues were, they were put to rest. So I don't know if I agree with complete surprise. It's just that it came now is probably not all that convenient, but he could have stuck around, assuming it was him and this really happened. He could have dealt with the police then. So I don't reward someone for basically remaining at large for 8 months on something where he's alleged to have basically hit somebody because they had the audacity to ask him, are you going to pay for that? And really elevates in about one short 2-second decision what's probably a petty shoplifting theft in a municipal court into much more serious charges against his backdrop. And I don't know if what you were trying to say is you don't think he has prior felonies, because it looks to me like there was a prior burglary and a stint in DOC. That by definition would be a felony. I certainly understand it's less convenient now for him. But to me, that doesn't garner any points for him, that he hasn't committed any other offenses or we would have caught him sooner. So this caught up to him now. That's just the way it is. This is more than your run-of-the-mill third-degree assault. Court is going to set bond the amount of $25,000 cash or surety with pretrial services, monitored sobriety, appear at all future court dates.
Can I say something here?
Comply with the
Mr.
mandatory
Waxer.
protection
You were
order.
saying I
Do not
was on the
violate
run.
state, federal, or municipal laws. What's that, sir?
Can I say something here?
Look, yes, technically you can speak. Nobody is physically stopping the words from coming out of your mouth. But here's the thing, you can also do a lot of things that would be a terrible idea. Just because you can do something does not mean you should. And standing in front of a judge while your case is already hanging by a thread, running your mouth without a single brain cell backing it up. That is the definition of doing something you absolutely should not be doing.
I mean,
Mr. Waxter,
you
Mr.
guys had
Waxter,
me fully-
Mr. Waxter, Mr.
No,
Waxter.
you had your chance to say something. I have something to say here. This is not fair. You're making it sound like I was on the run and evading everything. This wasn't even filed until Tuesday. I had no idea that this even existed. I mean, you're making it sound like I was evading and running everywhere. And I don't even know what this is going on. This is not fair, Your Honor.
Okay. Well, your attorney can take it from there. If you don't want the public defender, you can hire your own attorney. Return of charges February 24th at 3:30 in the clerk's office if you bond out. March 2nd at 3:30, you'll be in front of the district court. You can certainly lay that out to them. You have a long criminal history, and these are pretty serious allegations. So that's where we are today. That's it for today. Thank you.
Fuck you, Duane.
I got paperwork for it.
Thank you. Have a good weekend.
You as well.
Hey, come back over here.
This is fucking bullshit, bro. You heard what he just said, right? That I was evading and running for a year. They didn't even file these charges until Tuesday. I don't even know what they're talking about, bro.
Just come in here and have a seat so I can get the protection.
I don't even know what they're fucking talking about, man.
You're upset with it.
Fuck that dude, man. You want to see?
Thank you.
And that's a wrap on today's video, guys. Now I want to give you a quick update. I am actively hunting down the chicken guy's next courtroom appearance because that man is a walking comedy show and I refuse to let him disappear on us. As for our second guy, he actually had a court date just a few days ago, but I wasn't able to track it down. It's possible the date got moved, or, knowing this guy, he might have just not shown up if he managed to post bond. Either way, I am keeping both eyes wide open for these two absolute gold mines of courtroom entertainment. If you enjoyed today's video, smash that like button. If it wasn't your thing, hit dislike, no hard feelings. But no matter what, drop a comment down below and make sure you subscribe with notifications turned on so you never miss a single video. Because trust me, with guys like these still out there walking into courtrooms, the content is never going to run out.